Welcome, everybody, to Patriots Law Group Live. This is all about legal strategies for military divorce, and we are very glad that you're tuning in today. If you are an active service person or a veteran or even a military spouse and you are navigating a military divorce, you are definitely in the right place. We are here to bring you education, resources, some legal insights, and some tips to help you get through this process. And we have amazing two people, Mike Lyons and Pat Hughes, who are military legal divorce specialists, and they are going to be running the show today. And I have to tell you, we come up with a new topic every time we show up, and today is about custody and custody disputes, and one of the most emotional topics in divorce. And we're going to talk about 5 urgent terms that we have to settle in a military divorce. So I'm going to introduce first Mike. Welcome.
Thank you, Maureen.
Great to have you here. And Pat, welcome to the stage.
Good to be here.
Wonderful. Well, you are the gurus on this topic, and you are our specialist when it comes to military divorce and all of the unique challenges, the nuances, and you get into the real nitty-gritty on what people have to be aware of. So we always cover 5 points. We only have 30 minutes. And for those in the audience, if you have questions, we take those at the end. You can put them in the chat. So go ahead. Who's going to take number 1 for me today?
Yeah, Maureen, I think I'm going to take that one up front. So as you mentioned, we're going to talk about sort of the 5 urgent terms that you want to get settled in your military custody case. And obviously, the unique thing about a military custody case is the possibility of a deployment. And you want to get this settled because the settlement can be so nuanced and tailored to the situation of the service member, and just what their duty calls for and what their parenting ideals as well as obligations call for. So when you're thinking about this term, what you really want to do is to think about all potentialities. What's going to be the lead up to your deployment? Oftentimes there's training that occurs, shortly before you go overseas or you go on deployment. So how's custody going to change? Are you going to have weekends off? Maybe you want to say, hey, if I'm off on the weekend after I leave for deployment training, I want to be able to come home and exercise this access time. And then importantly, once the deployment ends, how does the custody arrangement snap back? Because that's what you want as a service member is really not a deployment creating either an opening for the non-military parent to say, hey, I'm now the full-time custodian because I've been doing it for the last 6 or 9 months while you've been deployed, which the court shouldn't totally take away custody based on a deployment of a service member, but the decision is a very holistic one, and an opportunistic sort of counsel on the other side and non-military parent could start to say, well, I enrolled them into this school that has this specialized program, and on and on and on, and the service members at a disadvantage. If your agreement specifically provides for, hey, judge, we've thought about this and we've agreed that once I return, the custody has to come back to me, then that puts a much higher hurdle and burden on the non-military spouse to say we should rip up that agreement that when we weren't in this weird time with this deployment and we're thinking amicably, thought was in the child's best interest. So I would say, number 1, get a clear roadmap for going into and coming out of a military deployment, which again can really only be done in a settlement agreement. The courts, when they're setting child custody in order, just use a real blunt butcher knife of a tool. So that's tip number 1.
Yeah, I mean, you never know what kind of judge you're going to get, but they're not supposed to hold the military service person accountable just because they're deployed, but it doesn't stop the other side from arguing it and potentially swaying a judge if they're influenced by that. And this would help avoid that entirely, right, by having it added into the settlement agreement. So another thing that we should add that we have our clients at is a mediation requirement. And I mean, with the formalities of going to court and just those things that you need to do to follow the proper processes, it's time intensive, and your attorneys work at an hourly rate. The more time that they're having to spend, the more it's going to cost you. And so we always try to bake in a mediation requirement in the settlement agreements that requires both sides to have to meet with a mediator maybe 2 times, 2-hour sessions, something like that, before they have the ability to even proceed to court. And so adding that term in there, oftentimes this neutral party who's mediating the session, well, they're experienced in family law. They'll be able to help try to get the sides to a meeting of the minds, but they'll also know and be familiar with the likely costs of going to court. And usually cooler heads prevail once you start putting dollars and cents next to what the battle is going to look like if they do have to go to court, and that may end up leading to some resolution between the parties and preventing any party from jumping the gun to go straight to court if you add this mediation requirement within the settlement agreement.
You know, right here when I'm listening to what you're saying, I mean, just regular deployments between a married intact family are difficult enough on children and having to manage this. Now you add in the separation and the divorce and coming back and forth. This can get really messy very quickly. So putting in, you know, very specific guidelines, a very specific structure that everybody can follow. I mean, this is one really tricky part of divorce when you add that other element in. And so I like the mediation aspect of this, you know, that third party that kind of comes in and trying to levels everything out. Like you talking about the cool head thing, because the temperature can rise really quick.
That's right.
Yeah. All right. Great way to start. All right.
Yeah. And nice thing about mediation too is, you know, the courts, if somebody violates the mediation provision, they may even dismiss the claim and say, go back to mediation. You can't come here until you've done it. So, so it really does, if it's in your agreement, provide a true opportunity to sit across each other face to face and really, even in the worst of situations, at least frame the issue. What are we really fighting about? So that litigation, if it has to go that route, isn't just open-ended, another great big mess on your hands, which I've seen. So,
and it leads to quicker resolution. I mean, if you're meeting with a mediator, you can do that. You can find somebody probably available in the next couple weeks. Whereas if you're dealing with a court, good luck. When you're getting in there, you know, it can take months. So
you'll be back from deployment.
Exactly. All right. Well, great. Right. So Pat, are you going to take number 2 for us? What's the next one?
That was number 2. I kind of segued, but the mediation, yeah, jumping from Mike on, you know, adding in some clear terms for deployment. I segued to adding in also a term for mediation. So Mike, I turn it back to you, my friend.
All right. So maybe we should say clear numbering in your settlement agreement. No. Yeah, no. So mediation is a great one, and you know, the third one, just for anybody that's keeping track of these, and it's the other messy reality of military life, and as a permanent change of station, PCS relocations, and just as I mentioned before, if a court's philosophy is I deal with things in real time, so if it makes a custody award, and schedule, it's going to say, this is what I think is in the best interest as of right now and these facts. And if something changes materially, you can all come back and talk to me. It doesn't like to deal in hypotheticals as to, well, next year this is going to happen and that is going to happen. And so it won't craft an order that says, well, we know husband or, the service member is going to leave in a year. So here's what's going to happen this year, and here's what's going to happen a year from now. It just simply won't do that. But in a settlement agreement, parties can do that. And I think, obviously every case is different. You need to talk with your lawyer and which side of the equation you're on. It may be pluses and minuses, but it really is, in my practice, can be a beneficial thing to set the terms out for what's going to happen in the event of a PCS. And there's two ways this works. One, and what we typically do and we write in ours, we'll use a mile radius type of thing that says, hey, in the event either party or in the event the service member, whatever, moves within X number of miles outside of where they presently reside or the school district or whatever, then custody and access is going to look like this. Maybe it's all of the 10 weeks in a summer and, the opportunity to exercise one weekend a month if they're present here in Maryland, something like that. Well, they are very far away. I'm thinking of a case where we wrote something like that, where the service member went to Hawaii. But then that also has language that says, if the service member returns within that radius that makes sense for joint custody again, rather than having to fight it and duke it out all over again, saying that joint custody is the default provision or position. And again, this is a tactical thing, because if there's nothing written about what happens coming back, the parent who remained and was the sole custodian during the period, the PCS to Hawaii, in my example, has all the advantages to say, don't disrupt anything. Don't do anything, judge. And they'll pretty much be able to stay in that sole custody situation until the court rules, which, as Pat pointed out, could be a year later, a long, long time later. But if you have this agreement in place, then it's saying what's supposed to happen. And anybody that wants to change it has to say, hey, judge, there is this agreement, and they have to follow it until it's changed. So you're in a much stronger position if you have written terms saying, when I come back into this area, here's where we've all agreed custody is going to come back to. Now, I won't say in every single case that, we have cases sometimes where we say the facts line up in such a very particular way, and this is an outlier of a case, that even though that agreement says that, we still aren't going to snap back into that schedule for one reason or another. So as I've said many times before, we've said, don't take this advice and believe that it's the gospel, or I should say this information, because it's not advice based on any particular set of facts, but this information, really, take it to a lawyer, to a legal assistance attorney, and decide what works in your case. But getting those terms into a settlement agreement very often is helpful to military parents.
So I have a question. Oh, go ahead, Pat.
I was just going to say, you see at times where, the overarching, I think, theme of this entire conversation that we're having today is be as forward-looking as you can be in the settlement agreements, to account for things that you anticipate will happen in the future. And you see a lot of times where people went the cheap route and maybe got a boilerplate agreement that they did on their own and didn't hire attorneys or what. And then all of a sudden, all these things that we're advising our clients to think about are often not contemplated at all. And it leads to further litigation and higher costs in the end. And so avoiding the what might be the easier or cheap route sometimes, or more often than not, I would say, is going to benefit the person by, sitting down with someone who knows all these things and can help contemplate for our clients what needs to be anticipated in the future because of how the military operates and what's expected on PCS cycles and so forth. We can add these things in that will then prevent the opposing party, or even just anyone really, to look at this and say, oh, well, we didn't think about this, now we got to figure it out again, or now we're in a dispute. I mean, there's nothing that prevents a settlement agreement from being modified if both parties reach an agreement and have a meeting of the minds later in time. If what was anticipated doesn't actually work out for either side's favor in the end, then they can modify it. But if all of a sudden someone's having kind of second thoughts and doubts about what they had previously agreed to, they're kind of stuck to it. Absent a showing of a significant change of circumstances that would mandate the court to get involved and change what the setup was. So that's why I think it's really important to hire an attorney on the front end who knows what they're talking about related to the military life, so that these things can be accounted for. And in the end, I think it's going to cause a lower cost than it would later in time, because you have to deal with all these things in the future as opposed to tackling them right on the front end. Am I ready to move to number 4?
Well, I had a quick statement or question. I had a question about this, and I can't imagine anything more sensitive than we're talking about children and everything. I can't imagine somebody taking the cheap way out on this. Really, I would think, if anything, a lawyer would be necessary in this situation, but maybe you see it go the other way and then have to kind of pick up the pieces as it goes. But out of the divorces that you see, do you find that in settlement that this one has changed the most, that you may be forward thinking, you may want to start that way, and you want to look at a year, 2 years, 3 years, but no matter how hard you try, I can't imagine these settlements being changed and updated the most? Just evolution wise, children involved, all the moving parts here. It seems this is the most complicated type of divorce involved. I just can't imagine, no matter how forward thinking you are. Is that in your experience that these are the most complicated ones that get changed and updated the most?
Mike, you want to go? Yeah, go ahead.
Yeah, no, I was going to say, military by far are the most complicated. Sometimes the military, depending on your career field, whether it's an MOS or an AFSC, whatever it is, sometimes there's limited places you can go, and you're choosing between staying in, is what your military is telling you, your command and your detailer or whoever, or staying home and being the parent. And so that's a real tension, because, not only depending on your career field, depending on your skill set, so if you're a pilot, you might have great job opportunities, but they might mean you're constantly away from home anyhow. If you're a Marine, then your opportunities may be sort of police force and weapons oriented. And so you can stay home. So there's all these sort of compete, but you probably don't have all the same benefits that military service provides. And so it is interesting to manage all of those competing interests when we are negotiating or advising service, what I call military parents, through this. And to your question of, do people make these agreements that don't fully account for it? And I think we see that a good bit, because you don't know what you don't know. And I think when you're in an emotionally charged environment like a custody case is, your farsightedness starts to be, or maybe not farsightedness, but your ability to see far starts to really be limited. And you just start feeling the friction of right now, how do we do day-to-day custody? How do we get to school and back? And that's where the frustration lives. And so sort of solving that problem is really, I think, without somebody who's been there and has a step back that says, well, pump your brakes. We can solve that problem, but that's going to set up another problem 9 months from now, because you're going to move, or you're telling me maybe you're going to move, and now getting the child to or from school isn't fair to the child, because it's a commute. If we went to the other side of the bridge in Virginia, it's an hour commute, right? So we see that, or we see an inclination with clients to say, let me just settle sort of in a generic way rather than a very specific tailored way.
But there's also, child custody and child support are two things that permit the court to intervene on what was previously a part of a settlement agreement. A lot of things that are part of a settlement agreement are non-modifiable. Once you execute it, it's a done deal, whether you like it later on or not. You're often stuck with it. But for child custody or child support, those are two things that can always be modified by the court if there's a significant change in circumstances. And so I think to the point that you were raising, Maureen, was, is this the one that you see the most that, people are looking to have modified? I think the answer is yes. Only, in addition to maybe things weren't accounted for fully, or things ended up changing, not as expected, then that can permit it. But also, it's just one of those ones that the court can intervene on, even though an agreement was previously reached. So on a fourth piece to the five that we're raising today, it would be to establish the school district in the agreement. To the extent that you can, depending on the ages of the children and all these things, if the parties intend to remain in the vicinity of the particular area they're in right now, or things like that, then you want to try to account for the school district, particularly if we're dealing with a 50-50 custody, which can happen. It's not terribly uncommon. I mean, sometimes the parties get along well, or they live close enough that the children are living week on with one parent and another week with the other parent, alternating. But all of a sudden things might come up where someone wants to move out of the area or something like that. If you've established the school district, this kind of controls, and you have to show some significant change in circumstances to try to avoid that term, and it does kind of like lock down the parties in a good way, I would say, to maintain the stability, because in the end, child custody, right? What is the court's standard of review? Well, it's whatever's in the best interest of the child or children, and so this would be a big part of it. Establishing someone in a school district and keeping them in that same school district is a fairly important thing, and so to the extent that the parties that can agree to and anticipate and build that into a settlement agreement, it would be advised as we see it.
It's all about stability. Yeah, it's all about kids. So it's great.
Yeah, you're surprised how many times the school district ends up being an issue and how many cases I've dealt with. I had one where somebody, wanted to change the schools because they had a terrific football player. And the father was very invested in helping that child become the best, football player he could be. And he was at a small school and no real, opportunities to do that. And so when he graduated from outside school football, like Pee Wee and that sort of thing, was ready to go to high school, having all these accolades, he wanted him to go to a school in DC that had a really great football program and football coach. We've had situations where people started out within private schools and then now they top out at 8th grade. And now it's suddenly, what do we do with high school? And there's two opportunities. So really thinking through, particularly if you have a situation like that, where the children are in a school that has a finite end, like maybe a private elementary school, what are we doing here besides teeing up a new problem? So Pat mentioned joint custody, and so I'll use that as my segue for number 5. We often have people come to us and say, "Hey, listen, the other party agreed that I would get tax, the ability to claim a child as a dependent for my taxes every other year. But the other parent continues to file for the child, and the IRS is kicking back my return because they're saying, this scenario is one where it's either exactly 50-50 or certainly in this easiest example is less than 50-50 is the person coming to us. So maybe to clean up this example, I'll make it. We have the parent who has a child, let's say a third of the year, and so probably 2 days out of every week. And the other parent has all the other days. Well, the IRS says that the parent with the majority, so the greater number of overnights or parenting time, has the right to that claim as a dependent on their tax return, that deduct credit, I guess. And it doesn't matter if you have a settlement agreement, the IRS is going to follow its own regs. So what I try to do in my settlement agreements is to put specific language about what the IRS needs in order to have the non-primary custodian claim it. Most of the time, it's every other year. And that is, as of today anyhow, that is an IRS form 8332. And what happens is the custody, the primary custodian has to sign it. So you have in your agreement, hey, if I present this to you, you must sign it and give it back to me in X number of days. And then if once it's returned, it has to be filed with the non-custodian parent's tax return. If both of those things don't happen, generally, the IRS is going to say, hey, sorry, the other parent claimed you didn't fill out that form. So here we are, you owe more taxes or you're not getting that credit. Without these terms, though, you are left to the whims of the IRS, and I think it's a publication 501. We don't give tax advice, so this is a generic sort of, I'm talking about sort of the legal mechanics behind getting somebody to do what's necessary as of today's IRS sort of framework. Super complicated publication and background, so talk to a CPA or look at that publication. But more than a few times, I've had to point out to people, what the IRS requires, and their agreement doesn't really provide that mechanism for them to get this form. And they either have no real relief to them or a real dogfight that makes the juice and the squeeze ratio way off, spending thousands and thousands of dollars to litigate over getting far less back in a tax return. So that's number 5. Good, clear terms on getting all the necessary documents to claim a child as a non-custodial parent is critical.
Excellent points. I mean, overall, these 5 points have been huge. And I think it's something most people, it's just not on their radar at all. Most of it is probably just, where is each kid going to sleep? Who's going to be the primary, person who's going to have custody. So excellent points. For those of you who have tuned in, and this is, your prime concern right now, I really hope you've picked up some of these insights. And Mike, I know that, with every show, we do want to let people know, a little bit of a disclaimer, because everybody's case is different. Do you want to share a little bit of what we'd like to let people know? Everybody's case is different.
Yeah, no, absolutely that. It is, this stuff is very tricky, and we give very, very, as all lawyers do, very, very tailored advice in every single case. And I'll tell you, there's probably 10 ways to approach every one of these issues, and getting a full handle on the case is the only way to give advice. So I highly recommend any military parent that's dealing with this and these issues, go to legal assistance. Find a lawyer that has some military background, or at a minimum, just find a lawyer and bring some of these resources, direct them to these LinkedIn Lives. I mean, we really are interested in hopefully serving the military community with some nuggets of information to issue spot. And, you know, for clients that retain us, specific advice, but for clients who just watch this, really just issue spot. So some professional can weigh in and say, in your case, based on the law as it is at that moment, here's the advice on what you should, quote, do. Okay. But yeah, no, I appreciate that, because I do think that's a really important piece of advice that we can give is really have skilled counsel guiding you through all of these questions and decisions and analysis.
Excellent. And of course, anybody out there who would like to retain Mike or Pat, and of course, Patriots Law Firm, you know what? We are here for you, and you can go to patriotslawgroup.com and learn more about them. We have an excellent resource center, like we talked about. These, you know, live streams are available, but there are plenty of other blogs. You can really dive deep into the mission and the vision of the company and get to know us better and better. So we hope you'll tune in next time. We are here every second and fourth Wednesday of the month with a brand new topic specifically geared towards military divorce. But again, Patriots Law Group, this is not their only specialty. You can go right on the website and learn more about all of the different legal issues that they serve in the military community. So please check that out. So we will see you in a couple weeks with that new topic. Thank you so much for joining in. We are also on Facebook and YouTube, so you can also see us there besides just live stream here on LinkedIn. So thank you very much. Thanks, Mike. Thanks, Pat. And I hope everybody's enjoyed this episode. We will see you in a few weeks. Thanks again.